Our next item is item 14, AB 1141 by Assemblymember Chow. Good afternoon.
Good afternoon, Madam Chair and Senators. I'm here to present AB 1141. AB 1141 would reenact and make permanent summary adjudication statutes that inadvertently sunsetted. It also corrects disparity in current law by equalizing the ability of both plaintiffs and defendants to recover post-offer expert costs. In 2011, SB 384 established the ability of parties to move for summary adjudication of issues even if the motion would not completely dispose of a cause of action or affirmative defense. If the court determines that the motion will further judicial economy. However, these provisions inadvertently sunsetted on January 1st, 2015. In 2005, an amendment to AB 1742, which was a non-controversial Judicial Committee omnibus bill, inserted the word post-offer into the Code of Civil Procedure, Section 998. As a result, when a plaintiff rejects a 998 settlement offer and fails to receive a better judgment at trial, he or she can be subject to both pre- and post-offer expert fees incurred by the defendant. However, if the defendant rejects a plaintiff's offer and fails to do better at trial, the plaintiff can only recover post-offer costs of expert witnesses. This inequity applies more pressure on the plaintiffs to settle cases rather than the defendant. Now, the bill AB 1141 does two things. Number one, it reinstates the summary adjudication provisions that inadvertently sunsetted. And two, it creates equity by allowing both defendants and plaintiffs to seek post-offer costs only for expert witnesses. And the most recent amendments have removed all opposition to the bill. At this point, I'd like to turn it over to my two sponsors from California Defense Council and also Consumer Attorneys of California.
Thank you very much. Please proceed with your testimony.
Good afternoon again. Sabina Tucker with the Consumer Attorneys of California, and we're pleased to co-sponsor this bill with Defense Counsel. This bill does two things. I'm going to speak to the 998 portion of the bill. This CCP 998 was enacted over 40 years ago to encourage parties to make and accept reasonable settlement offers. This bill will reinstate that purpose and by equalizing the statute. If you have any questions, feel free to answer them. Thank you.
Thank you.
Madam Chair and members, Mike Belote for the California Defense Council. I apologize to the committee for the inadvertent sunsetting. I should have caught this last year. I apologize to the Assembly. It was non-controversial. It allows a judge to hear a summary adjudication motion if judge, plaintiff, and defense all believe it will increase the chances of settlement or shorten the trial. It's judicial economy and efficiency. As to the second part of the bill, we agree that the 998 process ought to apply equally to both sides. 998 is a very complicated area of law that is applied differently in different areas of the state. There are conventions among courts. This cleans it up and says post-offer applies defense and plaintiff for both sides.
Thank you very much. Please note the lion is sleeping with the lamb. Both the Plaintiffs' Counsel and Defense Counsel are in support. Just want to point that out. All right, and other witnesses.
Laurie Dole, on behalf of the Conference of California Bar Associations, we're the co-sponsor of the provision relating to 998 offers, equalizing that, and we strongly support the bill.
Thank you.
Chair and members, Dan Pun for the Judicial Council. We're pleased to support the first provision in the bill that reinstates the summary adjudication. It's an important efficiency, and we urge your vote.
Thank you very much. Other witnesses in support? Are there any witnesses in opposition? All right, seeing and hearing none. Any questions? Move the bill. Moved by Senator Wieckowski. Any other questions? I want to thank you for doing this. This is a question of efficiency, and it is something that should apply to both sides. The goal being make good faith offers to settle, get cases resolved. We, generally speaking, you know when an offer is a good one, and I think it provides that necessary incentive and fairness on both sides to get these lawsuits resolved as quickly and fairly as possible. So I want to commend you for bringing this bill. There is a motion due pass to the Senate floor by Senator Wieckowski. Madam Secretary, please call the roll.
Jackson?
Aye.
Jackson, aye. Morlock? Aye. Morlock, aye. Anderson? Aye. Anderson, aye. Hertzberg? Leno? Aye. Leno, I. Monning? Monning, I. Wachowski? Wachowski, I.
6-0, we'll leave the roll open. Thank you very much, Assemblyman.
Thank you, Senators.
Next, we have file item, I think it's 16. Assemblymember Bloom. Oh, perfect timing. Assemblymember Bloom just walked in the room. You're up. File item 16. Absolutely. AB 1267. File item 16. Good afternoon, Assemblyman. Please proceed.
Good afternoon. Thank you, Madam Chair and committee members. Terrorism can take on unexpected forms, and today I'm presenting Assembly Bill 1267, which further protects Californians from something called paper terrorism. And that is the practice of filing legal documents knowing that they are false and meritless in order to harass, intimidate, threaten, or retaliate against public officials, law enforcement, and sometimes private citizens. And to protect victims of this conduct, AB 1267 strengthens already existing laws and increases discretion for filing officers. You'll hear more about it from my witness, but a case in point is something called the Sovereign Citizens Movement. The Sovereign Citizens are an extreme anti-government movement whose members believe that government has no authority or jurisdiction over them. The movement dates back to 1970, but it has had a surge of popularity since 2009, accompanied by a wide range of criminal activity that includes violence, scams, and frauds. Acts of paper terrorism can range from simple and straightforward legal filings, such as frivolous lawsuits, to more complex strategies, such as filing IRS forms that fraudulently allege victims have been paid large sums of money on which they declared no taxes. But the most popular paper terrorism tactics is the use of bogus liens or other documents to cloud title to property that's owned by victims. Whatever the ploy, the intended and actual result is serious legal and financial problems for those targeted, typically judges, elected officials, law enforcement, and at times private individuals. California law already protects public officers and employees who are targeted by these false encumbrances by allowing them to utilize a fast-track removal process. AB 1267 extends these protections to individuals and businesses so that they may all use this same expedient process. Also, under current law, when public officials and employees are targeted by a false encumbrance, they're entitled to seek civil remedies up to $5,000, and AB 1267 permits individuals and businesses to pursue these remedies as well. I'd like to introduce my bill sponsor, Joanna Mendelson, a California investigative researcher and director of special projects for the Anti-Defamation League, and she is one of the country's foremost expert on the sovereign citizen movement.
Thank you very much and welcome.
Thank you. Good afternoon. As mentioned, I'm Joanna Mendelson. I'm the California investigative researcher and director of special projects for the Anti-Defamation League. Since the 1930s, ADL, a national civil rights organization, has countered and exposed extremist groups and movements and the harm that they cause as part of our mandate to secure justice and fair treatment for all. For more than 2 decades, we have tracked the tactics and criminal activities of the extreme anti-government sovereign citizen movement. Sovereign citizens believe that the government has no authority over them because an insidious conspiracy has infiltrated and replaced the original legitimate government with an illegitimate, tyrannical one. Sovereign citizens essentially think they are above the law. Adherents to this movement engage in a variety of actions, including terrorism and deadly violence. However, more frequently, they use paper terrorism to harass, retaliate against, and intimidate law enforcement officers, public officials, and other perceived enemies. In the past 5 years, the sovereign citizen movement has grown and their criminal behavior has expanded. The Real Estate Fraud Prosecution Unit of the San Bernardino District Attorney's Office alone estimates the current caseload is comprised of 85% sovereign citizen cases. The most common paper terrorism tactic is to file bogus liens to harass public officials and law enforcement officers. But it has become more apparent that they are also regularly targeting private citizens and businesses ranging from ex-spouses and neighbors of sovereign citizens to lending institutions, media companies, and major corporations. Today, enough accounts of private citizens victimized by bogus liens have emerged to make it obvious that a problem exists and that private citizens need to be afforded the same protection that we give our public servants. California has had a long history with bogus liens. In the 1990s, for example, M. Elizabeth Broderick, a Palmdale sovereign citizen, filed so many liens that she became known as the lien queen. Most of those liens were filed against government officials, but she found time to harass others as well, including a $100 million lien against a local bank that had refused to accept a bogus deposit from her. Just this past year, James Mullen, a Chico florist, filed a bogus lien against a witness in a criminal case launched against him. ADL urges you to vote for AB 1267 and join the 25 other states which have passed similar laws. Please help protect the citizens of our state against the nightmare of paper terrorism. Thank you so much.
Thank you very much. Other witnesses in support?
John Lovell on behalf of the California Police Chiefs Association. Ms. Mendelson's reputation for research excellence precedes her. I can tell you, though, that that our member police agencies have been and individual officers have been victimized by this for the last 20-odd years. And when you get a whole host of liens dropped on your property, it is a serious, serious encroachment. This is a good sense bill that will expand the protections of current law that now protect police officers to extend to all citizens. We strongly, strongly support this bill.
Thank you. Any other witnesses in support? Are there any witnesses in opposition? Well, I can say that I know some judges against whom these liens were placed, and it is just the height of harassment and intimidation, and they are as lawless. I mean, it doesn't matter what your political perspective is. They just don't believe that they're subject to the courts. They don't believe they're subject to the laws and enforcement of them, irrespective of their political ideology. They just don't think there's any role for government. I think, you know, Somalia might be a great place for them to visit to see what anarchy is all about. But I appreciate this legislation, knowing that these folks really do try to undermine any semblance of order and law and sort of a rational society. So I appreciate your bringing the bill. And if there are any other questions, moved by Senator Morlock. Any further debate or discussion? All right. There is a motion. Would you like to close?
I thank you and ask you for your aye vote.
Thank you very much. All right. The motion is due pass to the Senate floor. Please call the roll.
Jackson?
Aye.
Jackson, aye. Morlock? Morlock, aye. Anderson? Anderson, aye. Hertzberg? Leno? Leno, aye. Monning? Monning, aye. Wachowski?
Aye.
Wachowski, aye.
6-0, we'll put that matter on call for the absent member. Thank you, Assembly Member. And now we have file item 19, or it's our last item, AJR 9 by Assembly Member Chang. Good afternoon.
Good afternoon. Madam Chair and Senators, in recent years, the U.S. patent system has been exploited at the expense of employers and entrepreneurs. Patent assertion entities, PAEs, commonly known as patent trolls, have found vulnerabilities in our legal system and use them as weapons to extract money from honest businesses. Patent assertion entities do not make or develop anything. They serve no other purpose than to sue entrepreneurs. They form shell companies and acquire ambiguous patents. They then aggressively use those to sue businesses for patent infringement. And they don't just go after the manufacturer of a product, but everyone who uses it. So while a so-called patent troll will go after a large company like Cisco for manufacturing a Wi-Fi device they claim is already covered by a patent, they will also go after corner coffee shops who happen to use the Wi-Fi technology. In fact, small to medium-sized businesses tend to be targets of patent trolls as they know the cost of litigating patents is very expensive. They depend on it so that they can force businesses into settling instead of enduring a costly court battle. Sadly, the cost of the average patent settlement paid by a small or medium-sized company is $1.3 million. And of the cases that do see a judgment, patent trolls lose 92% of the time, underscoring the questionable merits of their cases. Every time they are sued, entrepreneurs are forced to divert resources into litigation instead of investing in new innovations or growing their business. Collectively, this costs our economy billions. Patent trolls put innovation and economic growth at risk. And to be clear, there are legitimate patent infringement lawsuits, as there have always been. Our patent system is critical to ensuring inventors and entrepreneurs can protect their ideas. However, the rise of software and other technologies has proven difficult for the patent system to decipher between genuine patent infringements and someone simply using the legal system to make a buck. That is why it's so important for Congress and the President to take action on this issue, and I respectfully ask that you join me in calling on our federal leaders to reform our patent system in a way that puts an end to patent troll schemes. I respectfully ask for your support on AJR 9. And with me, I have Daniel Nazar from Electronic Frontier Foundation.
Good afternoon.
Good afternoon. Thank you, Madam Chair, and thank you for having me here. My name is Daniel Nazar. I'm a staff attorney at the Electronic Frontier Foundation, where I also hold the Mark Cuban Chair to Eliminate Stupid Patents. That was Mark Cuban's idea to name the chair that way.
That's what I thought you said, but I didn't quite catch it. Okay, thank you.
The Electronic Frontier Foundation is a nonprofit based in San Francisco. We have 22,000 members, and we work on free speech, privacy, and innovation policy. Thank you for your interest in patent assertion entity and patent policy. There is a big crisis in the patent litigation world at the moment. It's a new crisis, at least in terms of its scale. Patent assertion entities have been around for a while. There were some in the 1800s even. They called them patent sharks back in those days. But the scale of litigation is literally off the charts. We've gone from just a few hundred cases per year to thousands. To give you a sense of the growth, there were more patent assertion entity lawsuits filed in January of this year than there were in all of 2004. And these cases do tend to be of quite low value. In terms of the merits, the patent assertion entities lose at least 75% of the time when they're actually forced to judgment, and the most aggressive patent assertion entities, those that file more than 8 cases on a particular patent, they lose more than 90% of their cases when they're taken to judgment. And so what we're seeing here is a dynamic where patent assertion entities are using the cost of defense to leverage settlements. And the so-called bottom feeder patent assertion entities have a model where they ask for about $50,000, $100,000 maybe for a bigger company. And that's about equivalent to what it would cost you just for the initial answer or motion to dismiss in these cases. And they literally file hundreds. There are some patent assertion entities that have filed over 500 cases. A lot of them are targeting California companies, and they're particularly dragging California companies out to the Eastern District of Texas, where there's a sense that it's a pretty favorable forum for patent owners and a very, very expensive and inconvenient place.
The least they could do is go to the Barbados or Eastern Texas. Okay, thank you.
I concur. Barbados would be a much nicer place to litigate as a surfer. I agree.
All right, thank you. Thank you.
Thank you.
Next witness.
Is this on?
Senator Hertzberg, by the way, should be here because I think you match him in glasses.
My wife gave them to me.
It's quite all right. He'd love it.
My name's Tom Scott. I'm the executive director for California Citizens Against Lawsuit Abuse. We have 50,000 supporters statewide. Here to support AJR 9. To me, this is timely. The House is moving forward with the Innovation Act. The Senate is moving with the Patent Act. everything you're hearing here is that, I mean, California, I think I've heard, accounts for 25% of all the patents in this nation. These PAEs are, literally hitting industry for $29 billion. That is $29 billion that is not going to job creation. It's not going to the economy. I read one article, I think in Time magazine, that Apple and Google in 2011 spent more on patent lawsuits than they did on research and development. I mean,
Were those defending patent lawsuits or bringing patent lawsuits?
I took it to be defending, fighting, dealing with.
That might be an interesting question because, of course, they have patents that they want to protect as well. Yeah. Okay.
But to me, this is, AJR 9 is timely. Look, the president, Patrick Leahy, in 2011, was dealing with patent trolls. The president in 2013, 2014 has recognized the problem. This is the perfect opportunity to send a message. As the Assemblywoman has noted, look, all we're asking is for a balanced and workable approach to deal with this problem. I applaud the Assemblywoman. I hope you will see the avenue to support this, and I appreciate you taking the time to listen.
Thank you. Next witness.
Out of respect for your two witness rules, Andrea DeVoe, on behalf of TechNet, representing the nation's leading technology companies, thank the Assemblywoman for her important resolution and strongly support. Thank you.
Thank you very much. Other witnesses in support?
Good afternoon. Robert Callahan with the Internet Association in strong support, and thank the Assemblywoman for bringing it. And to the Eastern District point that was raised, 2 out of the 94 U.S. judicial districts handle roughly half of all frivolous patent lawsuits due to some of the loopholes in their rules. So I think it's an interesting point. They don't require early claim construction, and so discovery, which is one of the most costly portions, which result in a lot of the settlements, can happen prior to that claim construction. So,
thank you. Next witness.
Thank you, Madam Chair and members. David Gonzalez on behalf of the California Life Sciences Association. Happy to be here in support.
Thank you.
Michael Shaw, California Manufacturers and Technology Association, support.
Very good. Thank you. Any witnesses in opposition? All right. Well, I want to thank you also for bringing this issue because it is highly charged. There's no question about it. These lawsuits can be used as either a sword or a shield. And the reason I mentioned Google and Facebook is not that they're necessarily bringing them, but that they may very well to protect their patents. And so the notion that we need some balance here. If there's a legitimate infringement, that should be subject to the potential for litigation and protection of someone's idea, whether they're someone who works at Google or someone who works in their backyard. That's the challenge, I think. And so, I hear this discussion, and many years ago when there were violations of Business and Professions Code 17200, where we had a couple law firms in California who were shaking down small businesses, again, for the cost of litigation. They'd say, and I think Senator Hertzberg remembers this, that they were out there suing people or threatening them and recovering a substantial amount of money in lieu of litigation, because small businesses, of course, don't have the resources, or they don't have the sort of the general counsel, the stable of attorneys to fight back. But I think we did good work in diffusing that. We put some of those folks in jail, if I'm not mistaken, and that seemed to have been a good place for them. It's my hope that what we do come up with is balanced. Again, I don't see this as an ideological issue. If you've created a patent, you're entitled to protect it. If you're infringing on someone else's patent, you should pay for it. So again, the challenge is to reduce incentives. and minimize unnecessary patent litigation while ensuring that legitimate patent enforcement rights are protected and maintained. Now, that isn't something that we can necessarily do here in the state because patents are federally issued and so forth. But I would be very interested in hearing what the balanced approach is that you would see as something that we could do, again, to protect the interests, the legitimate interests of people and our, our innovators. Some of the patents that people create are fascinating and really take us to far more advanced places. And of course, here in California, where we invent the future, it's an important issue. So as I say, if there are any folks who have some suggestions on how to balance this, it probably, to the extent there's anything we could do here, I know that many of us would be interested in it. And otherwise, I hope that Congress comes through with a very fair and balanced approach to this. Lawsuits can be abused, but lawsuits are also a way people can protect and enforce their property and their rights. So we have to recognize both sides of that coin. So I just thank you for bringing this forward. Any other comments? A motion by Senator Morlock. Would you like to close?
I just thank you so much for your comments and respectfully ask for your aye vote.
All right. The motion is due pass to the Senate floor. Please call the roll.
Jackson?
Aye.
Jackson, aye. Morlock? Morlock, aye. Anderson? Anderson, aye. Hertzberg? Hertzberg, aye. Leno? Leno, aye. Monning? Monning, aye. Wachowski?
6-0, that measure is passed. We will hold the roll open for our one absent member. Thank you very much. Appreciate your. Okay. All right, so we will announce that vote. Senator Wachowski will not be back. That item, file item 19, is out. So let's go through all the bills one more time and call the absent members, starting with file item, starting with the consent calendar. Let's go ahead and call that again. All right, please call the absent members.
Anderson? Aye. Anderson, aye. Hertzberg? Hertzberg, aye. Leno? Leno, aye. 7-0.
7-0, the consent calendar is out. File item 1, SJR 13 by Senator De Leon. The vote count is 6-0. Please call the absent members.
Anderson? Aye. Anderson, aye.
7-0, that item is out. File item 3, AB 265 by Assemblymember Holden. The vote count is 4-0. Please call the absent members.
Anderson? Aye. Anderson, aye. Monning? Aye. Monning, aye. Wachowski?
6-0, that measure is out. File item 4, AB 289 by Assemblymember Melendez. The vote count is 6-0. Please call the absent members.
Anderson? Aye. Anderson, aye.
7-0, that bill is out. File item 6, AB 380 by Assemblymember Waldron. That vote is out, 7-0. File item 7, that vote is also out, 7-0. File item 8, AB 436 by Assemblymember Jones. The vote count is 6-0. Please call the absent members.
Hertzberg? Hertzberg, aye.
That bill is out. File item 9, Assemblymember Gomez. AB 560, the vote count is 4-2. Please call the absent members.
Hertzberg? Chair, aye.
Chair, aye. Excuse me.
Hertzberg, aye. 5-2.
5-2, that vote is out. File item 14 by Assemblymember Chow. The vote count is, I'm sorry, file item 10. I pass it. File item 10, the vote count is 5-1. The chair voting aye. Please call the absent members.
Hertzberg? Hertzberg, aye.
6-1, that bill is out. Then going to file item 14, Assemblymember Chow, AB 1141. The vote count on that bill is 6-0. Please call the absent members.
Hertzberg? Hertzberg, aye.
That bill is out. File item 16, AB 1267 by Assemblymember Bloom. The vote count is 6-0. Please call the absent members.
Hertzberg? Hertzberg, aye.
7-0, that vote is out. And we are done, all votes having been taken. I'm sorry. We are adjourned.